Member of Parliament and the ever-eloquent Dr. Tharoor, Chief Secretary Dr. Joy, our enthusiastic Vice Chancellor Dr. Rajkumar, my good friends Professors Venu Rajamani and Upasana, and Mr. Sudhir Mishra, ladies and gentlemen. At the outset, I'd like to congratulate Raj and his team at OP Jindal for putting together this conclave to discuss a matter which is of utmost importance in today's day and age. As the earlier speakers have already talked at length about the other development goals that were formulated by the global community in 2015 in their vision document for attaining those goals in 2030, I thought I would use this time to actually reflect upon some of the goals which have a bearing on the judiciary in our country. And I believe I'm eminently suited to talk on that because I'm an integral part of the judiciary in our country. Now, when you talk about goals 16 and 17 in the list of goals that were highlighted by the global community, they talk about justice, institutions of justice and participation. And both of these have a significance today when you consider that quite uncharitably, the vision document, when it talks about judicial institutions, says that globally, the two institutions which are most corrupt are the judiciary and the police. And I say uncharitable because when it comes to our country, just as Dr. Joy was mentioning about the achievements of the state in realization of some of those goals, and the ranking of our state is one of the highest in terms of its success rate in achieving those goals, I am proud to say that our judiciary in our state is 100% corruption free. And I'm proud to say that, and I'm proud to be a member of the judiciary, which also prides itself in claiming a great degree of success in gender equality. When you talk about our subordinate judiciary, 42% of our judicial officers are women. And we also have 5 out of the current crop of 35 odd judges in the High Court being women. And I don't think that record has ever been broken by any other state in this country. The figures, and I'm not making these tall claims just off the hat. There are figures which will actually prove whatever I said. But I say this only because I don't want any of you to leave this room with this awful feeling that maybe this institution of ours is a corrupt one, and therefore there's no hope as far as realization of self-development goals are concerned, or sustainable development goals are concerned. But having said that, let's see what the judiciary has actually done for the cause of environment. Now, if you look at it, the first comprehensive legislation that we had for environment protection was the Environment Protection Act 1986. Now, 1986 is a magical year because the legislation came in almost 13 years after the decisions were taken in the Stockholm Conference in 1973. Now, that speaks a lot about our legislatures. And no offense to Dr. Tharoor here, we actually look forward to contributions from him and the likes of him to have more speedy legislation coming in, because it can't take 13 years for us to legislate on something that was decided in 1973 and to give effect to it. And this is not an isolated instance, let me tell you. For those of you who are law students here, you would recall the case of Vishaka, the case which the Supreme Court actually laid down guidelines for tackling sexual harassment of women at the workplace. Guidelines were issued by the Supreme Court to hold the field till such time as legislation was brought in by the legislature. The legislation did come eventually in 2013, which is a good 17 years after the guidelines were laid down by the Supreme Court. Now, that just cannot be the case. You can't have the legislature sitting on something or a social evil and prescribing a remedy for that social evil after 17 years. So they have to act faster, and we look to people like Dr. Tharoor for ensuring that. But despite the lag in the legislation, when the legislation did eventually come in 1986, the judiciary did not waste time in interpreting the provisions of those meaningfully and proactively to read in concepts like sustainable development, intergenerational equity, the polluter pays principle, the precautionary principles, the proportionality principle, etc. And you have a line of decisions from 1986 onwards till the present day, fueled by increased public interest litigations, which also contributed to the cause of environmental litigation. You have a lot of them, and today we have no dearth of regulations and statutory instruments dealing with environment. Then what is it that actually ails us today? And this is what I want all of you to introspect on. There are a few issues that need to be flagged when it comes to the implementation of these proposals, which we have formulated and envisioned that they will be fructified by 2030. I have no reason to believe that we would not achieve those goals in our country and in our state in particular, because we have an able administration, we have the means, we have a very well-informed citizenry, which will all contribute to realization of those goals. But nevertheless, I thought it might be useful to just flag a few issues which I worry about when it comes to implementation of the proposals. First and foremost, the legislation itself in this country. Suppose you have a legislation that is brought in to combat a particular environmental situation. What you find in today's legislations common is that there is no effective deterrent mechanism for the defaulter. You do have provisions. It's pointless to have a fine of 500 rupees to a person who cuts down a tree. It really is pointless, because there is no deterrence, although it may be in principle a deterrent. You find similar provisions, and I was flabbergasted to read about the provisions in the Indian Penal Code when it talks about, because I'm an animal rights activist of sorts, and when it came to dealing with the stray dogs and protection of stray dogs, street dogs, I call them community dogs for a reason. I was flabbergasted to find that in the provisions of the Indian Penal Code, if you actually kill a community dog, the punishment is about 50 rupees for the first offense and 100 rupees for the next. And this is under the Prevention of Cruelty to Animals Act. The IPC doesn't take it much forward, because IPC treats the offenses against animals are not recognized as offenses against the animals. They're treated as offenses against the person who owns the animals, and therefore you find them under the broad head of offenses against property. Now, our legislation has to change. So you have to have meaningful, timely legislation which brings in a deterrent clause, which will prevent people from violating the provisions. So that's the first with regard to the introspection I need you to do. Second is when it comes to environmental adjudication. Now, we have forums for deciding the inter se rights of persons when it comes to matters of environment. You have the green tribunals now, and they are staffed by a judicial member and a technical member, no doubt. But at some stage, these matters do reach the High Court or the Supreme Court. And that's where the trouble begins. And if you recall, some of you may recall that before the green tribunals came into existence, we had only the High Court, and public interest litigations would bring cases before the High Court. Now, there is a danger when matters involving technical and scientific expertise come to a high court, because we judges are not competent to, we're not actually trained in scientific aspects, and therefore adjudication, which involves the fact finding, becomes difficult, and we rely entirely on the material that is produced before us. And the situation is not any different now just because you have a technical member on board in these forums. So what I would suggest, and I think deserves to be considered, is that the adjudication, which must necessarily be an interdisciplinary one, must be informed, or there must be an advisory body which will guide the adjudicating authorities on scientific and technical matters. And therefore, unless you have that kind of mechanism, the environmental adjudication, which today seems to be largely the fiefdom of lawyers and judges, will not be a success story. Third, and this is important, what we need most is a fostering of spirit of cooperation between the various branches of government. Now, for those of you who had the occasion to hear the Chief Justice of India talk yesterday in a conference of Chief Justices and Chief Ministers, you would have observed that the Chief Justice was virtually lamenting on two aspects. One, that there is an increasing trend of the executive not taking decisions and leaving it to the judiciary to take decisions at first instance. This is your average tahsildar. If you go to him with an application, he does not consider the application. He says, go to the court, get a direction, and then I'll consider it. This is not what the judiciary is there for. The second and most important is that whenever the courts pass orders and issue directions, they're simply ignored by the executive. And today, sadly, and this was something, I'm only echoing the sentiments of the Chief Justice of India, sadly in our courts we have another kind of jurisdiction which is called the Contempt of Court jurisdiction. Dr. Joy is here, and I hope he will take serious note of this. The buzz in the High Court today is that you have the heads of department in your various departments in the government issuing unwritten memos stating that whenever the High Court issues a direction which comes to that department, you need not comply with it till you get another memo which has a COC number on it, which is the Contempt of Court number. I sincerely hope that that is not the case, and that is not, because if it is nothing short of sacrilege. The orders of the High Court, the directions issued by the High Court, you can appeal against them, but you cannot ignore it. And that is a culture that needs to come in, because more than anything else, you should understand that under a constitution, the governance is entirely through a system of separation of powers, through a recognition of a system of separation of powers. And let the word power not actually get into your heads, because that is precisely what is causing the problem. When you get too heady on the possession of a power, then it leads to egoistic battles. And that's not what the Constitution envisaged it to be. A separation of powers under our Constitution is actually a functional separation of powers, where each body, each branch recognizes the functional expertise of the other. And when it comes to that, the legislature is competent to make the law, the executive to implement it, and the judiciary to interpret it. And today we are forced to make laws simply because the executive does not act or the legislature does not make them. The guidelines in Vishaka being a case in point. But it need not be that way. And I think in today's day and age, it's more a matter of inculcation of a healthy respect for the other branch of governance. And I think when we have a coordination or a cooperation between the various branches of government, then these issues do not come to the fore. I believe we can do it because of late we have seen positive signs in our state, and I speak only for our state now. In our state, we have been seeing a change. The compliance with legal directions is being taken seriously, and I congratulate the present government for that. The laws, we have able legislators, and I think we have some hope for the future. And if we develop a sense of maturity required for effective implementation of the sustainable development goals laid down by the global community, I do think that we can achieve those goals and we can taste success in those implementation well before 2030. With those words, I thank you all for your patience, and being the last speaker before Upasana formally proposes the vote of thanks, I would only like to add that the hope that kindles in my breast should also kindle in your breast, and please do not lose confidence in our democratic institutions. Thank you.